Welcome back to another session of business law. I'm actually doing my recordings back to back, so hopefully I'm going to have enough voice left by the time we get to the end of this chapter. So with this chapter, there's a lot of stuff. It's tort law. It's fun stuff. We'll probably be talking more about this as the chapter goes on. But there's a lot of fundamentals, a lot of definitions, a lot of principles. So the best way to do it is to just dive into it. If you have any questions, because there's going to be a huge amount of information. If you're having trouble following any of the concepts, let me know. Tort 2, usually this is taught over 2 semesters in law school. And here you're learning basically all the major principles in a matter of really kind of, one chapter, and watching this lecture as well. So I know that there might be some questions. In fact, there will be some questions. I want to hear from you. I want questions. I love questions. I'm not getting enough questions. Question away. Let's get down to it. Okay, tort. What is a tort? It's a civil wrong, not criminal. Civil wrong, not arising from a breach of contract. So it's anything that is not criminal, anything that is not a contract-related item. Everything else is what? A tort. So it's a civil wrong not arising from a breach of contract or other agreement, or as a breach of a legal duty proximately causing another person harm or injury. So somebody is injured because of an action. And if it doesn't have anything to do with contract, and it doesn't have anything to do with criminal law, then it's a tort. There's a lot of categories a lot of subcategories in tort. All right, purpose of the tort is to provide a remedy. Somebody's been injured. Somebody needs to be made whole, and they need a remedy for an injury to protect their interest. Now, that could be personal injury, or it could be an injury to your property, like somebody hit your car. All right, damages available in tort actions. So we got compensatory damage, reimbursement to the plaintiff for actual losses. I rear-ended a car, I'm sorry, I created injury, so you need to be reimbursed for your actual losses. This is X dollars for your new bumper. But we have special categories. Special for quantifiable losses, such as medical expenses, lost wages, and benefits. Those are categorized as special compensatory damages that are available under tort. What's the other one? General. Got special and general. So general for the non-monetary aspects, such as pain, suffering, and reputation. So special is the basically quantifiable. You can figure it out. This is X dollars for your bumper. General is basically vague, big picture, broad. So that's a good way to kind of connect the terms, like as far as general compensation. Let's make it fun. Let's just say somebody is part of the WWE wrestling, and they're a superstar, maybe like The Rock. And somebody ended up, putting something on the floor that was slippery. And The Rock was coming by, and The Rock slips and falls and suffers irreparable injury. Meaning irreparable, he'll never be the same. He can't walk right. Something happened to his hip, and surgery won't fix it. He will be dealing with pain and suffering for the rest of his life. And to compensate him for the pain and suffering, and he can't be a movie star anymore or a wrestling star anymore. And so because of all that, he's going to be entitled to special damages, not only the damages to pay his medical experts to fix or try to fix him, and to pay for the cane that he'll have to use and walk around with, but also the non-monetary, the non-quantifiable, the non-money damage part for his pain and suffering, that every day when he wakes up, he's going to have to think, boy, I can't get back into that wrestling ring anymore. Boy, I really can't be a movie star or action star anymore because of this injury. There's a lot of pain. There's a lot of suffering. And as I get up from this bed and dealing with emotional distress of it, there's a lot of pain trying to get out and maneuver out of the bed, just physical pain. I need to use a cane. And every day of my life, I'm going to have to start thinking about that when I wake up. There's not a day that will be back to normal. And that's what we're talking about with general damages. All right. Other damages available in tort actions. Punitive. Punitive damages is kind of like the last part. That if the action was just so crazy or so dangerous that the law and society allows plaintiffs to pursue punitive damages, which is basically punishing the wrongdoer to create a deterrence for somebody else to do the same thing. So let's look at it from a business perspective or a corporation. That, say, Microsoft got in trouble for certain practices. And the actions were just so egregious. And its competitor, Apple, is watching this case because they know that the plaintiff is asking for punitive damages, punishment. And if those punitive damages are awarded to the plaintiff against Microsoft, Apple is going to look at that and say, hey, we're in the same industry. We're developing a similar type of product, and we're doing it much the same way. Microsoft got in trouble, and they got slammed with this punitive damages. And usually punitive damages are in the millions. It's usually huge to act as a deterrent so that if Apple sees this happening, say, this happened to Microsoft, this could happen to us. We need to change our ways before we get sued just like Microsoft. All right, there's been legislative caps on damages because like we said, that punitive damages are sometimes in the millions. Now, who makes the decisions as to the damages? And it's usually the jury, if it is a jury trial, if there was a jury demand made going back a few chapters. So sometimes the juries award something that's huge. Nobody really ever thought about it. And the plaintiff's so happy that this is more than they ever hoped for. But because sometimes these damages are so big that they're having a negative impact on society, say the company can't afford it, we need that company, it's going to bankrupt the company. So sometimes the lawmakers define the caps as to what could be awarded to a plaintiff for a certain type of action. All right, classification of torts. There are two broad classifications of torts. There's the intentional and unintentional. So, you know, the person who put down something slippery on the floor when the rock was running, say, for instance, it was another wrestler that was all jealous about Rock's success. So he knows that the Rock is going to be running down this path. So he made it intentionally slippery with the intention of creating injury in the hopes that then if the Rock is not able to participate because of his injury, that he could step forward. That would be an intentional. But say, for instance, somebody was just mopping up the floor, trying to get it all nice and clean, didn't expect anybody to cross that path, but somebody did. That would be unintentional. So classification of a tort largely depends on how the tort occurs. What are the surrounding circumstances? What was going on at the time? So there's defenses. So plaintiff files a lawsuit, and what happens? The defendant gets served, and now they have to go ahead and defend themselves. The defendant can raise a number of legally recognized defenses. A successful defense releases the defendant, here's the part, partially or fully. So the defenses that they come up with may be that, look, maybe what I did contributed to the injury, but also, the plaintiff, when he injured himself, you know, if that person used a little bit more due care themselves, they would have never been injured. So I'm not fully responsible. I'm partially responsible. So some of the defenses are there to compare who's more at fault. If the person who injured themselves is more at fault, we'll see later on there's comparative negligence. So that'll be toward the end of the lecture. I'm sure you're really excited to get to that part. So let's keep on plowing forward so we could talk more about it, right? All right. Available defenses can vary depending on the tort involved. So is it trespass? Is it personal injury? Was it intentional or unintentional? So those defenses are all going to be part of that. So intentional tort. The tortfeasor. Yeah, fancy word. Tortfeasor. The person who committed the tort must intend to commit the act. You cannot be held liable or should not be held liable if our justice system is working properly. That if you did not intend the torts, then you shouldn't be held liable for an intentional tort. So it's a fundamental element. If you didn't intend for that tort to happen, and if you didn't intend for the rock to run down and slip on the floor, then it won't be, and it can't be intentional tort. It would be categorized as something else, unintentional. So he intended the consequences of his act. Yes, I'm going to make the floor slippery. Ha ha ha, the rock is going to go ahead and slip and fall. He intended that the consequence would happen. He knew substantially, with certainty and with hope and wantonly, that certain consequences would result. I'm going to go ahead and put extra soap in here to make it extra slippery when wet. So when the rock runs down here, the rock most certainly will go ahead and slip. So he intended the consequences and knew with substantial certainty that the certain consequences would result. Okay, transferred intent. Say, for instance, I'm going to get the rock. You know, he beat me. I deserve to be champion of the World Wrestling Federation. Well, it's entertainment now. It used to be Federation when people thought wrestling was real. So say, for instance, he's making the floor all slippery for when the rock runs down to enter the arena, but something happened. The rock wasn't feeling so good. He had a tummy ache. And so instead of the rock, they had a fill-in. Say it was, I don't know, the Hill. The upcoming wrestler, the Hill. The Mountain, maybe. The Hill and Mountain, whatever you want. So now the Hill, the Mountain wrestler is coming in, and the guy sees who's making everything slippery, who wanted the rock to fall. It's like, oh no, that's the Hill. He's my buddy. I don't want him to slip and fall. Whoa, whoa, whoa. But it's too late. The Hill and the Mountain fall. And now the Hill and Mountain is injured. So even though this person intended for the rock to be injured, but the Hill and the Mountain wrestler, in place of the rock, because the rock was feeling ill, ended up slipping and falling. That, even though that was unintentional for the Hill and the rock to be hurt, it transferred over to the Hill and the rock. You intended to hurt someone, but someone else got hurt. That person could pursue an action of intentional tort, even though the person who was intended to be hurt ended up being somebody else. If you intend for a person to be hurt, it doesn't matter who gets hurt. It could be a different person, but if you have intent for a specific person to get hurt, if somebody else got hurt, then that somebody else could pursue an action in court for intentional tort. You would not have the defense to say, oh, this was unintentional, Judge. I meant for the rock to be hurt, not the Hill and the Mountain. He's a good friend of mine. I would never want him to be hurt, Judge. Judge is going to say, sorry. We have a concept in the legal industry called transferred intent. All right. Assault. It's kind of like there's something that comes with it. It's like peanut butter. You don't just want a peanut butter sandwich. When you get a peanut butter sandwich, you want something with it, like peanut butter and jelly. So usually assault comes with another term, assault and battery. But both are separate legal consequences and actions. So assault is any intentional and unexcused threat of immediate harm or offensive contact, whether words or acts, that create reasonable, believable threat. So as I'm like, I'm gonna get you, and I'm about to go ahead and hit the person, but I stop short, that's an assault. So an assault, for it to be committed to have an action against somebody, there doesn't have to be a touching. Just, I'm gonna get you, but you stop short, that's still an assault. No physical contact is necessary for an assault to occur. Now, when we get the peanut butter and jelly sandwich out of this here, the assault and battery, that means that the battery is the completion of the assault. So instead of stopping short, you actually hit the person. So it's the unexcused and harmful or offensive physical contact intentionally performed. So the contact can be made by the defendant or by some force set in motion by the defendant. So again, the assault is the threat. And then the battery part is the completion of the threat. The person got hit. But just say, for instance, I'm going to get you, and you slip. You didn't mean to hit the person, but you ended up touching that person. You set the force in motion, whether you meant to hit them or not, whether you just meant to commit the assault and just stop there. You never meant to take it to the next level of battery. Assault, I could deal with that. That's a legal action, but I never really wanted to be liable for assault and battery. I slipped. It's not my fault. It was wet. I don't know. Somebody was mopping and something about the rock and the mountain and the hill guy. But once the force is set in motion, whether you intended the touching or not, you're going to be held potentially liable for that. False imprisonment. Oftentimes we'll see this with maybe shoplifting in a store, in the business setting. So it's the intentional confinement of another person or restraint of another person's activities without justification. That, you know, the security store security doesn't like this person. You know, this person he sees dated his sister, that relationship went sour. And so, like, I'm going to get back at this person. I'm the security person. I'm going to go ahead and confine this person, even though I didn't see him shoplifting. I'm going to get back at him this way. That would be the intentional confinement of another person or restraint of another person's activities without justification. That would lead to a false imprisonment claim. The confinement may occur through the use of physical barriers, being stuck in a room that's locked, or a cage, a physical restraint that you're in handcuffs, or it may not even have to be with physical barriers. It's just the threats of physical force, saying that, look, you move, I'm going to hurt you. You don't even have to show a gun. You're just saying, you move, I'm going to hurt you. Take one more step, I'm going to hurt you. That could rise to a level of false imprisonment. All right, infliction of emotional distress. So taking or having certain actions against an individual, you may create a lot of anxiety in a stressful situation. It creates emotional distress. And that's a tort too. An intentional act that amounts to an extreme and outrageous conduct resulting in severe emotional distress to another. You've held somebody in confinement with a gun in hand. That's creating a very stressful anxiety situation. That's an extreme and outrageous conduct. So that could rise to a level of an infliction of emotional distress. The act must be extreme and so outrageous that it exceeds the bounds of decency accepted by society in order to be actionable. Okay, so the infliction of emotional distress, the First Amendment's guarantee of freedom of speech limits emotional distress claims when the outrageous conduct consists of speech about a public figure. So say, for instance, your action was such, with outrage, it was extreme, outrageous conduct, and it could be outside the bounds of decency. If you do that to just a private citizen, you will potentially be subject to an intentional emotional distress claim. But if you do it to a public figure, that you say certain things, because they've put themselves out there as a public figure, their ability to have recourse against you is limited and minimized. So what's a public figure? If you voluntarily put yourself out there as an actor or an actress or a politician, that basically there is more that a person could say about that person and be protected under the First Amendment for freedom of speech. But that is also limited. So the next concept is defamation. What is defamation? Defamation involves the wrongful hurting of a person's good reputation and image. The law imposes a duty to refrain from making false statements of facts about others. So you don't like a person, so you're going to go ahead and start spreading rumors that puts that person's image and reputation in false light. That is defamation. And there's a law that imposes a duty that requires us from refraining from making such false statements about others. When there's two different categories of defamation. So we have slander, and these are hard to remember which one's which. The best thing to do is just kind of keep on repeating in your mind. So slander has to do with oral breach of the duty of refraining from making false statements. So slander relates to oral. When it has to do with print or media, also including the internet, that is libel. All right, so to establish defamation and to prove up a case, the following elements need to be established. The defendant actually made the false statement. The statement was understood as being about the plaintiff and nobody else. That statement was made, the statement was understood to be about the plaintiff and tended to harm the plaintiff's reputation. The statement was published. It needs to be published to a third person and not just the plaintiff. It has to be published where somebody else sees it and hears it. If you've made this false statement to the plaintiff and the plaintiff is the only one who heard it, then this action would fail. If the plaintiff is a public figure, if you put yourself out there as a public figure, as an actor or as a politician, the plaintiff also, the public figure has to show that there was actual malice in that statement. That actual malice, we'll learn a little bit more about this, that you knew, or the defendant knew, that this was truly false and was just taking such outrageous actions that they wanted to go ahead and really get back at them, even though they truly knew was false and recklessly was trying to wreck the reputation of a person. So basically, certain statements that are defamatory, that maybe are not true, a public figure has limited rights to pursue the action. But if they could establish that the defendant had malice intent in mind, that they really just wanted to destroy this person and were making false statements, even though they knew that they were false, then if the public figure could say, look, I still could pursue this against the defendant because they acted with malice. So defamation, published statement must be a fact. So statements of opinions are protected speech under the First Amendment and not actionable. So if the published statement that wrecks the reputation of a person, if it's true, if that statement is actually true, that happened, that's in that fact is wrecking the reputation. If it's true, then the cause of action for defamation fails. Truth is always the solid defense for defamation. So publication requirement, the false statement must hold an individual up to hatred, contempt, and ridicule in the community and be publicized or communicated to a third party. Defamation for libel, general damages are presumed, and the plaintiff does not have to prove actual injury. So again, what's libel? What is written, anything that's in the internet. Damages include compensation for disgrace, dishonor, humiliation, injury to reputation, and emotional distress. And remember, the general damages, not special. Special, remember, has to do with the quantifiable. I broke your bumper. Here's $500 to fix it. General has to do with things that are not necessarily quantifiable. You can't go ahead and just replace disgrace, replace dishonor, replace humiliation and injury to reputation. That this is something that they're going to have to deal with potentially for a lifetime. And when they're looking for damages, that would be under the category of not special damages, but general damages. All right, damages for slander. Slander again, oral statement. The plaintiff must prove special damages, that there is a quantifiable damages that need to be established. So slander per se, though, is an exception, and no proof of damages is necessary when the statement involves a loathsome communicable disease. That this person has this contagious disease, stay away from this person, you go near this person, you're going to die, then that's slander per se. And in that particular case, no proof of damages are necessary as a required element to prove up a case successfully. Business improprieties, serious crimes, or serious sexual misconduct. Defenses to defamation, as we talked moments ago, always a defense. Truth. Truth is generally an absolute defense for defamation. You can't handle the truth, from that one popular movie with Tom Cruise in it. Privileged or immune speech. So that's a defense too. Absolute privilege and qualified privilege as defined by law. Defenses to defamation, absence of malice. False or defamatory statements made about a public figure or privilege unless they are made with actual malice. Malice, again, is knowledge of falsity or reckless disregard of the truth or falsity. Invasion of privacy is another tort. Common law recognizes 4 acts that qualify as improperly infringing on another person's privacy. Invasion of privacy continues. So here, intrusion, the 4 parts. Intrusion on individuals' affairs or seclusion. Publication of information that places a person in a false light. So defamation, as we just learned moments ago. Public disclosure of private facts. If there's something that is private, you've made that known to people and publicized it, that would be an invasion of privacy. So medical condition. But what is already public? Like, this person has a $1 million mortgage against this house. And that mortgage is recorded with the county. And even though nobody knows about it because nobody's looked at the public records, but since it's been made public at the county or the government, then that would not qualify as a public disclosure of private facts because that information was already public. Appropriation, use of another person's name, likeness, or identifying characteristic for commercial purposes without the owner's consent. So I'll just say LeBron James. And say Foot Locker uses LeBron James' image. They have a poster in front of the store and it's trying to lure people in to go ahead and buy shoes that LeBron James would wear. They're using, Foot Locker's using LeBron James's image and likeness without his permission. That would be an appropriation LeBron James would have an action against Foot Locker. Now, this really happened with Michael Jordan. Dominic's grocery store, gone for many years, but it was a very popular grocery store. They used Michael Jordan's image in advertisements. Michael Jordan had filed an action for appropriation and won in that action. Okay, fraudulent misrepresentation. In other words, fraud. Intentional deceit. Fraud is you deceiving intentionally, usually for personal gain. This tort has several elements: misrepresentation of material fact, intent to induce another to rely on the misrepresentation, and justifiable reliance by the innocent party. So, fraudulent misrepresentation, damages suffered as a result of the reliance. There has to be a connection, a causal connection between misrepresentation and injuries suffered. And the fraud is more than just puffery. In other words, seller's talk, trying to go ahead and encourage somebody to purchase a car because it's super fast and it's very sleek, it's got a nice color to it. So very important. So we're going to come back to go over this one more time. Fraud has to be intentional. Intentional deceit, misrepresentation of a material fact, intent to cause or induce somebody to rely on that misrepresentation, and the person justifiably relied on it. An innocent party said, okay, you said it, I relied on your statement. And as a result of that statement and reliance, that innocent person suffered damages. And there has to be a connection between the misrepresentation and the injury. There's got to be a link to it. And it's got to be more than just puffery. So like, this is a fast car. It's, it's a sports car. Those things are not. But when you start saying that, look, this car has a new engine, buy this car, but then the engine wasn't new. That's intentionally deceiving somebody to rely on a statement that causes damage, because when the person who was driving the car away, the engine died because it was too old and too worn out. So they bought the car with the understanding it had a new engine, and now damages occurred. All right, abusive or frivolous litigation. I'm just going to get back at this person, so I'm just going to file a lawsuit. I know I'm probably going to lose because I don't really have any, claim. I'm just going to make it look like I have a claim just to make this person's life miserable. So torts related to abusive or frivolous litigation include malicious prosecution or abusive process. So another tort is wrongful interference with a contractual relationship. That occurs when the defendant knows about a contract between A and B. And now, that person is jealous about that contract. They wanted that sale. So intentionally induces either A or B to not fulfill their obligations and promises in that contract. That they're coming in and saying, hey, buy my product instead. I know you're in a contract with somebody, but you should go ahead and deal with me. That person is bad. And so now if you're making those claims, there could be multiple counts like defamation. So when somebody knows that two people are linked to a contract and there's a third person who's trying to come in and break things up, then the person who is on that original contract could have a cause of action against that third person for intentional or wrongful interference with an existing contractual relationship. So wrongful interference occurs when there's an established business relationship. A and B have to have that established relationship. The defendant uses predatory methods to cause the relationship to end. They know that there's something going on between A and B. They've got a contract and they want to go ahead and sever it. They're taking intentional, contemplated acts to go ahead and break up that relationship. That's predatory methods. And then the plaintiff suffers damages because of the breach of contract. So that plaintiff could have a cause of action against the other person on the other side of that contract and against that third person who was breaking things up. So there's defenses to that. So the interference was justified or permissible, maybe by law, or maybe it was just competitive behavior. There was just an email blast that caught the attention of the other person on the party, and that email blast, like, I could get the same product for less money, so I'm going to go ahead and break my contract with A, and I'm going to go ahead and contract with C. But it's basically B that decided to go with C. C had nothing to do with trying to break things up. C didn't even know about the existing contract between A and B, so that was just competitive marketing behavior. So C would not be liable under an intentional interference or wrongful interference of an existing contract under such circumstance. So trespass to land is another tort. Occurs when a person without permission physically enters onto, above, or below the surface of another's land, or causes anything to enter onto the land, like a drone, for instance, or you throw a stick, or remains on the land when pretty much was asked to leave. So liability for harm, a trespasser is generally liable for the damage caused to the property and generally cannot hold the owner liable for injuries sustained on the premises. So if a trespasser goes into a farm, goes into the barn, and they knock over a lamp and starts a fire, and now as he was trying to escape that fire, he trips and sustains injury. So the trespasser cannot hold the owner liable for his injury because he's the one who is trespassing, who's wrongfully there. And plus knocking over that lamp that created the fire, now the trespasser is going to also be responsible for the damages to that barn. Many jurisdictions use a reasonable duty of care rule that varies depending on the status of the parties. Property owners may be liable for objects that attract children under the attractive nuisance doctrine. So going back to this part here, say for instance, though it's a child, the circumstances now are going to be a little bit different because there's a doctrine called attractive nuisance doctrine. So say for instance, in that barn, there was a horse, and that child was just crazy about horses. And so is being attracted to that barn. And so the property owner knows that that child is living next door and even has become aware that that child just is, obsessed with horses. And knew that, that child may go ahead and trespass onto the land to go near that horse. So with that knowledge, there is a reasonable duty of care that that property owner has to take to make sure that the child is not trespassing or has reason to trespass because of that attractive nuisance, that they're just being attracted to enter onto the land, and it's a child who doesn't know any better. So the landowner could be held responsible under those circumstances. Defenses to trespass to the land. The trespass is warranted, necessary to assist someone in danger. So somebody sees that there's a fire and there's a person that's screaming out for help, and that trespasser who's screaming out for help, there's another trespasser that sees that person from the street. I'm going to have to go and help that person. And that person trespasses onto the land to help somebody who's in danger. Then that's a defense. It was necessary to assist someone in danger. The trespasser is a licensee, so that's a defense too. That utility companies. So ComEd comes to try to fix the electrical supply that's going to a neighbor's house, and you don't like that neighbor. So ComEd, the electric company's coming in to try to fix that connection. You know what ComEd is up to. That, like, I don't want you to come on my land because I know what you're going to do. You're going to fix my neighbor's electrical supply. I don't like that neighbor. I don't want that neighbor to have any electricity. I'm going to get back at them. So Mr. Electric Man, if you come in on my land, so I'm going to go ahead and have a cause of action against you for trespass. The utility company is a licensee in almost all circumstances, so they have a right to go on the land to provide services to everybody else in the community because it is for the public benefit. That if there's a disconnect at one end that is not providing utilities to a city, then the utility companies have an inherent right as a licensee to go ahead and to enter onto the land and not be held responsible for trespass. All right, trespass to personal property, the intentional interference with another's use or enjoyment of personal property without consent or privilege. So that's, I ended up leaving my iPad on my desk at Harper, and somebody comes and takes it from me. They knew it was mine, but they wanted to use it themselves. That's the intentional interference of my property. And since that person took it, it took away my ability to use it and enjoy it. And I didn't give that person any consent or privilege to do that. So that's a trespass to personal property. So yes, you could have a trespass for not just land, real estate, but also personal property, maybe even like a car, for instance. So with that, we have subcategories of conversion and failure to return the property. So conversion is the wrongful possession or use of property without permission. So that person who took my iPad converted it and started using it as their own. So they're wrongfully possessing it and using my property without me telling them that that's okay. This could happen with money, and it does. This is something that lands a lot of accountants and attorneys in trouble when they're holding money on behalf of a third party, their client, perhaps, and they're like, you know what, I'm gonna go to Vegas. I don't have any money to gamble with, but I'm holding on to $2,000 of my client's money. So I'm a good gambler. So I'm gonna go ahead and take that $2,000 and go to Vegas for a week and then come back. I'm gonna put that $2,000 back and I'm gonna enjoy the $4,000 I made out of it. That is conversion. Even if you go to Vegas, you take that money for just a few days, an hour, a minute, it doesn't matter. If you take somebody else's money, use it for your own benefit, and you put it back, it was never really even at risk, you've crossed the line of conversion, which could get you in a lot of trouble. So never, ever in a professional setting, use a person's property, money, tangible, intangible, doesn't matter, and convert it as your own, even if you intend to put it back. That's conversion, and that rises to a cause of action. So failure to return goods, even if the rightful owner consents to the initial taking of the property. So, like, sure, you could use my iPad. So the person says, hey, Mark, can I use your iPad? I say, that's fine, but make sure I get it back. So I've given consent to the initial taking. Yes, you could use it. I'm thinking that you're going to use it for a minute or two, but it was never returned. So then basically that gets converted to a conversion for failure to return the goods, even if you intentionally had permission. So the defendant can't just say, look, you allowed me to have it. Yeah, but we're supposed to return it to me and you never did. So now I have a cause of action against you for conversion because you took it without the proper permission to have it as long as you did. Okay, disparagement of property occurs when economically injurious falsehoods are made about another person's product or property rather than about the person's reputation. So don't buy this person's canoe because if you do, you're going to sink. And say that that's a falsehood and you're a competitor because you sell canoes too. And you're trying to get people to be induced to purchase your canoe instead. So you're starting to spread falsehoods, and that's a disparagement of property. So with that, we've got the subtopics of slander of quality. So slander, again, what's verbally said. Publication of false information about another person's product, or trade libel. So something that's written. Slander of title is the publication falsely denies or casts doubts on another's legal ownership of the property, resulting in financial loss. So like, don't buy the canoe from that person because they don't own the canoes. That person is not the owner of the business. The real owner is out of the country on vacation and doesn't realize that that person is selling his products. But say that that's not true. Say that the person is the actual owner. But the competitor is saying that that person doesn't really own it and doesn't have the right to sell you the canoe. So they're trying to encourage them to purchase their product instead. So they're casting doubt on another person's ownership of the property. Don't buy that car from that dealership because they stole that car. They don't have legal title to it. That would be slander of title, or give rise to that action. All right, unintentional tort, a wrongful act that a tortfeasor, there's that fancy word again, person who commits the tort, committed without knowing its wrongfulness or without intending to commit the act. So remember, we were talking about intentional tort. I'm going to go ahead and get back at the Rock. I'm going to make this all slippery here. When the Rock runs out to go out to the stadium to introduce himself to the crowd, he's going to slip and fall. That's intentional. But say, for instance, that, you know, it's slippery there because you're trying to get it nicely cleaned and didn't realize that Rock is going to be coming out at that moment, and now the Rock slips and falls. That's an unintentional tort, a wrongful act that tortfeasor committed without knowing its wrongfulness or without intending to commit the act. I'm so sorry, Rock. I thought you were coming out like an hour and this would have had enough time to dry. I just looked at the schedule wrong. It was wrongful for me to not look at the schedule, but I didn't intend for this to happen. I'm so sorry. So negligence is the failure to live up to required duty of care that a reasonable person would exercise in similar circumstances. So if somebody's mopping up the floor, what's the reasonable duty of care? Is to put up signs. Caution, wet floor. That would be what is usually exercised in similar situations, but you chose not to put up those signs because maybe you didn't have them, you were tired, you didn't think about it, you forgot about it, then that would rise to negligence. Intent is not required for negligence. So if you're being negligent and you hit rear end a car, you didn't intend for it to happen, but because you were texting at the time, that's engaging in an act of negligence. So intent is not required, only the creation of the risk of the consequences experienced by the plaintiff. Texting while you're driving, you're creating a risk, and now you've damaged somebody. So that's negligence. So in negligence, plaintiff has to prove the following. So now, with the Rock slips and falls and saying that you were negligent by not putting up a sign saying that, the floor is wet. So the Rock would argue that, look, you had a duty to put up those signs. So there's a duty. And because you didn't put up those signs, there's a breach of duty. Defendant breached that duty by not putting up the signs to warn somebody that there's a slippery floor. And because there's that duty, and because that duty was not performed, you didn't put up the signs, and now somebody runs out and slips and falls, and that caused the injury. If the sign was there, then that person would have not been injured. But because there was a wet floor, there was no sign, and the person runs out, slips and falls, that duty was breached, and now that breached duty caused the injury. And now the Rock is seriously injured. He has to use a cane for the rest of his life. He can't do action films anymore. So now he suffered damages. So a legal injury. Duty of care and breach. So the courts consider the following factors when determining whether a duty of care was breached. The nature of the act, mopping up the floor, creating a wet surface, the manner in which the act was performed, and the nature of the injury. So reasonable person standard, the degree of care expected. So when the courts are trying to figure out what is the reasonable care, is a sign good enough? Should you put up tape? Should you have neon flashing lights? So to determine that is what a reasonable person would say is necessary. Yeah, just the yellow signs is just sufficient. But maybe in some point in the future, there should be a barrier, that maybe caution tape surrounding the area, because sometimes you might not be able to see the sign because they're really small and depends on where you're coming from, may not be properly placed. So maybe in the future, that won't be necessarily sufficient enough to a reasonable person. So that could change over time from case to case. The judges will go ahead and the jury make a determination whether or not a reasonable person would think that just a caution sign, slippery when wet, is sufficient. That could change, where somebody may say, because of these particular circumstances, because you knew that somebody is going to be running out to the stadium and you made that whole entrance area all wet, there should be caution tape. There should be more than just the sign. So degree of care varies and depends on the dependent's occupation or profession, her or his relationship with the plaintiff, and other factors. So is this a person who just was doing their duties, didn't understand what potentially that area is being used for, or the person who's mopping up knows exactly the relationship and knows that this specifically could happen? The duty of care will be increased under those circumstances because there's a higher expectation because of your connection with the person, with that person's connection to the rock, to the industry, to WWE, because this is not their first rodeo. There's a higher duty of care versus somebody who's just completely disconnected, unconnected, didn't even know who it was. All right, duty of landowners. Landowners must exercise reasonable care to protect persons on their property from harm, even trespassers. So basically, if somebody trespasses onto your land and you don't have your area fenced off, even though you've got a swimming pool, you have a duty of reasonable care to protect the persons, to put up a barrier around your swimming pool. Even though the only way that somebody could get into your swimming pool is if they trespassed, but they still have a duty of care to protect any trespasser from entering onto your land and then potentially drowning in your swimming pool. And again, that would be the same thing with an attractive nuisance. A swimming pool could be an attractive nuisance to a child who likes to swim and is going to the neighbor's house to take a dip when nobody was around, but then the child ended up becoming seriously injured or dying. And if there was a fence that was put up, that would have protected the trespasser, protected the child from attractive nuisance, and lives would have been spared. So it would be reasonable care to put up a fence. The landowner must exercise reasonable care to protect persons, even if a trespasser. Business owners must warn invitees of potential harm on their premises. So if you're mopping up at Starbucks and you don't put up that sign and somebody slips and falls, that person who's coming in to buy coffee is an invitee. And since you didn't warn that person of that potential harm, then there is a breach of that landowner's duty to exercise reasonable care to protect persons. And then obvious risks require no warning. So Starbucks may say as a defense, look, they saw the person mopping. The person was actively mopping at the time. It was snowing out. The only reason why the floor was wet and being mopped at the time is because everybody was coming in with their messy boots, with their wet boots. That Starbucks may say to a reasonable person, it was an obvious risk. The snow is out there. It was a big blizzard. So, most people would know that, if you come in from the outside and the floor is wet, it's an obvious risk. Will it fly? Depends on, with that argument of defense fly, it depends on the, surrounding circumstances, the judge, and also the region where the case is being heard. Duty of professionals. Professionals always will it will always be considered whether or not they owe a higher duty of care based on special education, skill, or intelligence. So, so basically, an attorney, a doctor, will have a higher degree of requirement for duty of care. That's when you're representing somebody or you have a client or customer that you're supposed to be engaging in certain business that's looking out for the client's best interest. There's a fiduciary duty, a special fiduciary duty is a special relationship, special bond that you have to that client, and that because of your special education as a doctor or your skill as an accountant or intelligence as some other professional, that you now are held to a higher standard. There's a bigger expectation that you're going to go ahead and exercise a higher duty of care. So a breach of duty is called a professional malpractice. So if a doctor, was out the night before partying and had a really bad hangover and was supposed to do heart surgery, and because his body was impacted by this, and there's a whole bunch of evidence, videos, documentation indicating that, he was out partying, he was held to a higher standard of duty of care and breached that duty, so the patient could have an action for professional malpractice against that doctor. Causation. Even though a tortfeasor, a person who commits a tort, there's that thing, that's a fancy word again. Even though a tortfeasor owes a duty of care and breaches the duty of care, the act must have caused the plaintiff's injury. So if there is a breach, but there is no damage or injury that's related specifically to that breach, then there is no cause, there's no link. There's got to be a link from one to the other, that there was a duty, there's a breach, and because of that duty and breach, it caused the injury. If there's no link to that, then the cause of action for negligence would fail. So causation, in fact, did the injury occur because of the defendant's act? Did the rock fall because he slipped on the wet floor? Or would the injury have occurred anyways? That the floor surface was already slippery, that it wasn't that, the mopping made it any worse, that the floor surface and, the shoes that the rock was wearing, just combination of both would have caused that injury to happen, that the rock was going to slip regardless of whether or not the floor was being mopped. If it could be established, that could be a defense to a case. The proximate cause, when the causal connection between the act and injury is strong enough to impose liability. That, you've made it really wet, very slippery, more so than usual. Even if the rock saw that was slippery, but because you put in certain additives that normally wouldn't be used in commercial practices, then that's the proximate cause. The causal connection between the act and injury, it's strong enough to impose that liability. Foreseeability. Defendant owes a duty to protect plaintiff from foreseeable risks that the defendant knew or should have known about. A foreseeable risk is when one is in foreseeable risk is one in which the reasonable person would anticipate and guard against it. So the defendant owes that duty to protect the plaintiff from foreseeable risks, so that if Starbucks knows that by mopping up this floor, it's foreseeable that that person might slip, then they're going to have to put up a sign because they could foresee that wet floors, I'm mopping, somebody might slip unless I give them warning. So a foreseeable risk is one in which the reasonable person would anticipate and need to guard against it. Yes, as Starbucks, I know that the floor is going to be wet and I need to protect my invitees, my consumers, my customers from slipping and falling because I could foresee it. So the injury requirement and damages to recover, plaintiff must show legally recognizable injury. Compensatory damages are designed to reimburse plaintiff for the actual losses. I rear-ended your car. Here's $500 for your bumper. That's compensatory damages. Punitive damages. Remember, punitive damages are designed to punish and to deter from others from the wrongdoing. That this, Starbucks didn't put up the sign, and so they got sued, and then the plaintiff also went after punitive damages, and the jury awards them $3 million, even though the injury is only $10,000 to pay for all of the medical bills and things like that. But to serve as a punishment and deter others from wrongdoing, the court and the jury awarded the punitive damages. And that's designed to have a competing coffee shop. Long ago, we used to have another coffee shop in addition to Starbucks called Caribou Coffee. And so if Caribou saw this and says Starbucks got in trouble for not putting up their sign while mopping, and there were punitive damages that was in excess of millions. So what we need to do is make sure that we're careful, because it's going to deter us from acting the same way as Starbucks. That's why punitive damages are there. It's an attention grabber, so that other businesses in the industry sees that, look, they got in trouble, we're doing the same stuff, so we got to make sure that we don't end up in the same boat as Starbucks. Okay, Good Samaritan statutes protect someone who renders aid to an injured person from being sued for negligence. So basically, we need to have some protection that somebody goes ahead and tries to help somebody who's injured. And say, for instance, in the process, while they're trying to help somebody who's injured and keep that person alive, they put them in the car and try to go ahead and get them to the hospital. But in the process, they've created some injury. Maybe they would have been better off by not being moved around so much. Maybe their back injury became worse. But because there was intent to try to render aid to somebody who's injured and get them to the hospital because they thought the person's life otherwise was in jeopardy, the law is there to protect that Good Samaritan as well. There's still some duty of care, but generally there is some law to help protect that Good Samaritan, because why? Nobody else would want to go ahead and help or provide aid if they know that they could be sued. Dram Shop Act has to do with bars and restaurants, so liability for injuries may be imposed upon bartender and the bar owner. Assumption of risk. A plaintiff that knows, so the plaintiff, the person who received or has been injured, knows the risk and voluntarily engages in it anyway, may recover from the alleged tortfeasor. So bungee jumping, for instance, it's a dangerous act. So, that person ends up being injured as a result and now sues the bungee cord operator. And the bungee cord operator is going to say, look, they assume the risk. They know inherently bungee cord jumping is dangerous, and they knew the risk and they voluntarily engaged in that risk anyway. So that's my defense. So that plaintiff assumed the risk. So why should I be responsible? So risk may be assumed by express agreement or be implied by the plaintiff's knowledge and conduct. So with the example of the bungee cord, say for instance, there is no agreement. In itself, we know that's inherently a dangerous activity, but there also could be a separate agreement that you sign off on a waiver. So if you have both, then you're ending up putting yourself in a better defense position. Okay, superseding cause. An unforeseeable intervening act that breaks the causal link between the defendant's act and the plaintiff's injury, relieving the defendant of liability. So one of the constant themes is that there's got to be a link between the breach of duty and the actual injury. If there's some sort of intervening act in between that really created the injury, then the link was broken. And so even if a breach or a duty was breached, since there was an intervening act in the center, that link has been broken, and that is also a defense. Contributory negligence under common law, doctrine of contributory negligence. If the plaintiff caused his injury in any way, he's barred from recovery. So this kind of depends on the region and the state, but basically, if you cause your own injury, you may be putting yourself in a situation where trying to go ahead and go after a defendant saying that you've injured me. A defense could be that, look, plaintiff, you're the one who caused your own injury. You wore slippery shoes. My floor otherwise is not slippery. So comparative negligence, most states have replaced contributory negligence with the doctrine of comparative negligence. So if, you know, the plaintiff, the person who was injured, had hurt themselves, their actions created their injury. But at the same time, in that same event, what the defendant did with the wet floor maybe had contributed to the injury, then what the courts and juries are going to do is try to figure out, it's a balancing act. There's the scales of balance. So if the defendant caused or created the injury and it's dominant, so more than 50%, then the plaintiff likely is going to be able to recover something with the comparative negligence theory. But if it's determined that the plaintiff is more at fault, the plaintiff's ability to recover is going to be significantly diminished at that point. So comparative negligence computes liability of plaintiff and defendant and apportions the damages appropriately as to percentages. That's, you know, plaintiff, you were 30% at fault, so you could recover 70% of the damages from the defendant. Pure comparative negligence allows the plaintiff to recover even if his liability is greater than that of the defendant. So the comparative negligence, modified comparative negligence, percentage of damages that the plaintiff causes are subtracted from the total award. 50% rule, plaintiff recovers only if liability is less than 50%. 51% rule, plaintiff recovers nothing if liability is greater than 50%. Wowzers, that was a mouthful. So every semester, the tort session, there's a couple of chapters that are kind of like this where there's a lot of concepts, but for the most part, not very difficult ones to grasp, just to become aware of them. So if you have any questions, make sure you let me know. So, but we're gonna have one more chapter after this. It'll get us from chapters 1 through 7 at that point, and then quiz time. So make sure that you're preparing yourself for the quiz. That will be coming up pretty soon, before you know it. So trying to catch up at the last minute and cramming is not going to do you any good. So minimize your stress and anxiety and dedicate certain time for your studies on a daily basis. Not easy to do. I was, you know, telling somebody else that one thing that helped me when I was in your shoes is that just like I needed to eat and sleep, I had the mindset that I also needed to study. And this is to allow you to achieve your future goals. And it's not always easy to stay dedicated. Life gets in the way. But if you stay committed to it and you do it for a certain period of time, a sense of self-obligation occurs and satisfaction too, that I've been able to do it this long. I'm not going to let myself down. I'm going to go ahead and stick through it, even though I don't feel like it. I'm not feeling well. I've got this going on. I'm going to go ahead and dedicate that time. I'm just going to do it. Just like you need to eat, you need to sleep, you also need to go ahead and focus on making sure you get through your college career in a successful way. All right, so enough of that soapbox. Thank you for joining me for another session of business law. Look forward to seeing you in chapter 7. Hopefully I'll get most of my voice back after this. Take care. Bye-bye.